a gender-based violence advocacy group called Embrace Project, together with a rape survivor, have filed an application at the High Court challenging the constitutionality of the criminal law, specifically the Sexual Offences and Related Matters Act and its definition of consent. Now, the organization is arguing that its current form, the law, is insufficient to prove that an accused person committed an act of sexual penetration without the complainant's consent. Now, let's discuss this, and we are joined by Lee-Anne Germanos Manuel. She is the co-founder of the Embrace Project, and we're also joined by the rape survivor. Her name is Inge. To both of you, thank you very much for your time and availing yourselves for such a sensitive topic. Inge, I'd like to start with you because as a rape or as a victim of rape, this is one of those heinous crimes that not only violates your dignity, but it also violates your bodily integrity. Without going into too much detail, are you able to tell us what happened?
Yes. I was invited to a party, and it turned out that it wasn't actually a party. I was the only person there, and I kept asking when the other people were arriving, but they never arrived. And I started feeling like I was having an out-of-body experience. Obviously, the accused in my case raped me, pinned me to the couch, and then afterwards wanted me to stay over the night and everything, although, you know, you had just raped me. So I just tried to get out of there as fast as I could.
Lee-Anne, let's come to you. Having listened to this story, you have taken up Inge's case. What is it that you are arguing in court that makes the Sexual Offences and Related Matters Act not stand up in terms of its constitutionality?
Thank you. Thank you for having me and for the opportunity to explain this. So just to give a little bit of a background as well to what happened with Inge and how we even got here is Inge actually reached out to my organization through social media when we were having a series on sexual consent and the difference between what the law says sexual consent is and what social sciences says it is. And she then told me about her story. And what really struck me was when her matter went to trial, and I say this sort of like quite cautiously, she was one of the more fortunate survivors whose case did have its day in court, and you know, the matter was taken to trial. But in her case, what really struck me was her judgment. In the judgment, the magistrate said that she had found that 3 out of the 4 elements for rape had been proven. The 3 were unlawfulness, the absence of consent, and also an act of sexual penetration. But that one particular element was not proven, and therefore she had to acquit the accused. And that element is the element of intent. And that is actually the reason why we've taken her matter as a test case to court to actually challenge all the provisions in the Sexual Offences Act that deal with sexual offences where the main element is consent. And the reason I say this is because when it came to Inge's case, and unfortunately a lot of survivors actually experience this when they go to trial, the court, or rather the state, couldn't prove that the accused person subjectively intended to rape her. So in her judgment, in the magistrate's judgment, she explained exactly what Inge had explained. She explained what had happened to Inge and how her reaction was to freeze. So Inge didn't necessarily object, although in her case, she said she may have objected, but the accused person may not have heard her. So she didn't necessarily object verbally or physically by pushing the perpetrator away. And as a result of that, something as simple as that, and something that is actually so profound and so fundamental when it comes to victims of sexual assault, they tend to freeze during the act of sexual assault. That is actually the most common response. And so because she didn't object, so because she didn't play the perfect victim in terms of the eyes of the law, which is to object to what was happening to her, the magistrate couldn't find that her accused person had actually intended to rape her. And that's how he got off. And the magistrate had even quite specifically stated in her judgment that she found him to be an unreliable witness, that he contradicted his versions, he was extremely arrogant, and that she believed Inge and her version, but the problem was the law.
Yeah.
And that is why actually we've gone to court.
Inge, having listened to Lee-Anne, how does this make you feel that the magistrate found that 3 of the elements fitted perfectly with the crime that the perpetrator had committed against you, but it is the one element of intent that got him to basically be acquitted of this crime? How does that make you feel?
To be honest, it's quite difficult. And in the beginning, it was even more difficult. And I tried to understand, but why? I even went and bought the Sexual Offences Act and, started reading it. And then I got into contact with Lee-Anne. I don't know, I was following their page at the time, and suddenly this message popped up or that type in here sort of question, and that's how I got here. But it is very sad, and I do think it happens to a lot more people than we're aware of. It's not if someone doesn't hold a gun to your head or a knife to your throat, it's incredibly difficult to prove what they intended in their mind.
And Lee-Anne goes into quite a lot of detail describing what the magistrate said about the behavior of the perpetrator, particularly his attitude in court, found him to have been arrogant, unreliable. In your view, do you think that it is fair for the magistrate to have acquitted him, given the kind of behavior that he displayed?
I think that's a very difficult question, because she can't really do anything other than follow the law. So ideally, I would have wanted the person that I know did this to me to be behind bars, but the law also has to be followed. Even though she does believe me and it did happen the way I said it happened, you can't not follow the law.
Lee-Anne, Inge is a very brave person for wanting to tell her story. And in this effort, this is also part of, this is what she wants to also do, to get the law changed so that the other people that fall victim to this kind of heinous crime actually do go away for a very long time. Talk to us about where things are at the moment then to try and get the law to be changed if we are going to be successful at this.
So, like you said, Inge is extremely brave. She knows that even if we are successful in this application and we get the law changed, and I'll explain to you exactly what it is that we're seeking to do, Inge's case can never be retried. And she will never be able to actually see her perpetrator behind bars. And that's actually the most heartbreaking thing out of this whole case, out of this whole challenge. But even knowing that, she was willing to come forward and to say, well, I know that it's too late for me, but hopefully it won't be too late for others. And in coming forward and in being brave enough to speak her truth and to tell her story, she could potentially change the lives of millions of potential victims in the future. And what we hope to do and hope to achieve by, her coming out and us bringing this application is we actually want the law to change when it comes to the question around intent. At the moment, there is a subjective test that is being used by the court, where the question that the court asks is, what was the state of mind of the accused, personally, subjectively? Did he or she believe that they were committing an act against the will of the complainant? And that's the question that the court currently asks and has answered by the state. And you can imagine that it's almost impossible to prove that the perpetrator's subjective state of mind was that he believed that he was actually committing a rape when he's telling the court that he didn't believe that. So what we want to do is to change that question from one that is a subjective test and question to an objective test, where the question is instead, objectively speaking, looking at the facts and looking at the circumstantial evidence, could a reasonable person have come to the conclusion that consent was given? So we're moving away then from the subjective state of mind of the individual accused and actually asking, what would a reasonable person come to in terms of a conclusion?
Yeah.
And the magistrate actually in her case said that if the test was a reasonableness person test, she would have found him guilty. And that is what we are trying to achieve. And it's not something unusual what we're asking for. There are a number of jurisdictions throughout the world who have changed their rape laws to this reasonableness test because they found obviously that the subjective test is archaic, it is unconstitutional, it doesn't achieve what is meant to be achieved. Why is it that we're still asking what is the subjective state of mind of an accused person? Because the more perverse their background is, where they might be taught to believe that no means try harder, the higher the chance is that you're going to be acquitted, because that's subjectively what you've been brought up in and what you've been brought up to believe. So what we want from the court is to declare these sections unconstitutional in terms of these specific definitions or these specific parts of the definition, and read in a requirement where perpetrators are required to take all reasonable steps to ascertain whether or not consent is given. So now immediately we're shifting the onus onto an accused person to show that consent was given, as opposed to putting it on the state to determine that there was no consent. And that little shift in the focus from, proving an absence of consent to proving the existence of consent, that will make all the difference.
Yeah. Inge, we're concluding this conversation, and I want to once again repeat what I said to Lee-Anne, that this is a very brave step on your part to talk about your story and to allow for your face to be shown so publicly on a national television. It talks to perhaps the support structure you have at home. Talk to us about that. How supportive has your family been, and what would your advice be to potential victims?
Yeah, that's a difficult one. But I do have an incredible support system at home. My mom was the first person I told. I wouldn't necessarily say willingly. She asks a lot of questions. But my mom, Clinton, sister have been there for me since day one. And they're still there for me. And it's not always easy, and we all have good and bad days, but yeah, I think they help me be strong. But definitely the Embrace Project and the entire legal team involved in this, I would never have been able to do it without them. I don't know if they give me so much strength. But I don't necessarily know what the best advice would be for other victims and survivors, but I do think speaking out and finding a support system is definitely really important.
Yeah.
Knowing you're not alone, because you're not. Our statistics are incredibly shocking. Chances are you know someone who has gone through it. They just haven't said it in a public forum. So, and to seek support from, whether it be a psychologist, friends, family, just anyone who can be there for you.
Yeah. Inge, I don't know what to say, except to say that you're a very brave person, and thank you very much for the effort you are doing, because you are trying to make a mark in the history of this country's laws, and if it does get changed, it is going to be all thanks to you and the brevity you are showing right now. So keep going, and let not what happened to you put you down. We are all here for you. So thank you for telling us your story. Lee-Anne, any final words from you as to where to from here?
So we are going to be heard finally after 2 years by the Pretoria High Court on the 22nd of July, which is on Monday and Tuesday. We're really looking forward to finally having the matter heard and hopefully having a judgment in the matter soon enough. I think a point worth noting is that the Minister of Justice is unfortunately opposing our application for various reasons. And yeah, we've seen some concerning attitudinal remarks in the minister's response to our application, and we really hope that with this case that not only will the court find in our favor, but that hopefully the department as well as the South African government as a whole will change their attitude towards gender-based violence and victims and women in particular.
Yeah, and that is very disheartening, what you've just said, the attitude of the Justice Minister. I'm lost. I'm at a loss for words for why would this be the approach, but I guess we're going to have to go through all of the motions here in order to get to the finality of this matter. I want to thank you both very much for your time and taking us through this process. It is a learning curve, I suppose, for people who may not be aware of this. And I have to tell you, I'm learning about it as I talk to you right now. Lee-Anne Germanos Manuel, let me thank you very much for your time, a co-founder of the Embrace Project. And Inge, once again, you're a very brave person. Thank you very much for talking about this, because that's part of the healing process. Thank you indeed for your time.
Thank
All
you
right.
so much.
Thank you.